grateful at this moment that I have to convince 12 jurors who use their common sense and wisdom, not a defense attorney. Because the defense attorney is involved in the confusion illusion. Remember I told you about that? Mr. Hessman just stood up here and said there was only one gunshot out there that day. Well, I can show you 8 holes in Ben's body. And if he doesn't believe my photo because he's so fearful of these evil cops, he should ask his client. Because his client sat there and testified about multiple gunshot wounds. The evidence is what the evidence is, not what Tim Hessman, the defense attorney, wishes it was. Confusion illusion? Ashley wasn't nervous. Nobody ever said Ashley was nervous. Well, there is a person that said Ashley was nervous. Do you remember? His very own client said Ashley was nervous. If you get out State's Exhibit 85, which is the murder timeline, what's going on that morning? When she's getting kind of agitated because Michael isn't there because of his car, he's telling him, Ashley's so nervous, Rachel too. What do they got to be nervous about? Well, maybe they're a little nervous for their friend going out on a divorce, to ask for a divorce. Maybe that makes them a little nervous or something, okay, if that's what really has happened. But if that's what really is happening, why do these 2 women, as Mr. Hessman concedes, Rachel really didn't do anything? Why do these 2 women need an alibi? Why do they go to the convenience store if all that's going on is a divorce request? Why does Ashley send a message while they're gone, placating and setting up the alibi about the kids being picked up by Ben? Because there's a conspiracy going on. And Mr. Hessman keeps acting about this proffer. Why does Rachel need a proffer agreement? Ladies and gentlemen, the cops come to you. I'm going to let you in a little secret. Sorry, guys. But if the cops ever come to you, don't ever talk, okay? You know, and that's what Rachel knew. Is, first of all, she did talk twice. She lied twice. And when they came at her harder, she got an attorney. The same thing Ashley did. And what a proffer agreement is simply this. You tell us the story, and if it checks out, we may or may not give you a deal. And that's done with her attorney and the prosecutor. But the important thing is that Mr. Hessman said far-fetched, and he wasn't saying the evidence, my evidence was far-fetched. He was saying it's not far-fetched to make up evidence. He's making up evidence. It's not far-fetched to believe that these 2 gentlemen had a quarrel in there and one of them said something that pissed the other one off. There's no evidence of that. What's far-fetched is this defense in this case. We've heard a lot about Brandon Blackwell. Brandon doesn't sound like a nice man. And you know what I think hearing about Brandon Blackwell all day establishes in my mind is that with the exception of Ben Renick, Lynlee's got terrible choice in men. Okay? For some reason, she's got terrible choice in men. And when people's lives, as Mr. Hessman described to you, unravel, things are going wrong, they unravel, stress comes in, what do people whose lives are unraveling in front of them? What do? Sometimes they take chances. They take risk. They make bad mistakes. And Lynlee Renick did that. Now, we keep hearing about shooting somebody in the back. It takes precision. Well, as Mr. Hessman pointed out to you by asking the witnesses, some of these were close contact, right up on top of the body. But I would submit to you, any of us, if that's Ben Renick, and I'm following him down that narrow hallway, any of us could shoot him in the back from this distance. But it appears, based on Mr. Hessman's questioning of the witness, they were closer. Any of us could stand over him, and if it's a surprise attack, sneak attack that she did on her husband, he doesn't know it's coming, so he's just walking straight, he's not moving, dodging. He goes down, any of us could stand over him and finish him off, like she or her ex-boyfriend did. Mr. Humphrey is involved in drugs. Let's blame Mr. Humphrey. He's a bad drug guy. I guess he had drugs in his system and wigged out that day. Well, the only problem with that is if Mr. Hessman would listen to the evidence, his own client said, Michael looked normal that day. He was fine. Okay? But more importantly than him looking fine, let's remember who invited Michael to this party. Lynlee Renick. After 7 years of no contact, she needed, according to her, to get divorced. She needed to go along with her for support, make sure things didn't go bad. And out of all the people in her life, she chose him. Now, ladies and gentlemen, this is out of character for Miss Renick. It's not out of character for her to be dishonest, to be deceitful, to lie, to cheat. She admitted to being all of those things. And she admitted to some of the most horrific lies possible. And in our criminal justice, that horrific lie is probably falsely accusing somebody of rape, or, God forbid, falsely accusing a completely innocent man of the murder of his own brother when she knows otherwise. On top of killing her husband, I'd submit to you that's another crime.
Please approach, Your Honor.
Gentlemen of the jury, I keep hearing how Lynlee was so haywire that night. She was so out of it. She was catatonic. Her brain was vaporized. For 2.5, 3 years. At some point she came to well enough to tell him it wasn't a snake on the night it happened. But on the weeks, months, and years that continued down, she was less catatonic, less hysterical. She was competent enough, mentally acute enough to see the internet chatter, to continue the cover-up of Michael Humphrey's murder by telling the police the cover story about the massage and about the car stereo. She was acute enough. She was cool enough. She was cruel in her heart enough to not tell any of her friends that Michael Humphrey did this crime. She was cool enough. She was cruel enough to blame this crime on the dead man's brother. And she did all that, why? Because she wanted to get away with it. Find her guilty and send her to prison like she deserves.
I'm gonna give the complete set of the instructions to the bailiff. I've told you repeatedly, till you're sick of it, not to talk about this case. Well, now it's time for you to do so. You can retire to deliberations with the exception of numbers 55 and 58. You two need to stay in here. The rest of you go with the bailiff.
All right.
Okay, you two are obviously the alternates, okay? And I don't want you to feel like you wasted your time. We appreciate your service. You need to be kept separate from the jury in another room, and you're going to take them there, right? Okay, and until further notice, all right? All right, that's what we're going to do. Counsel, just stay in the courtroom a minute. Okay, can I, let me ask you, do you think you're going to put on any evidence if we get to a bifurcated stage of the trial? What about the defense?
I'm not sure yet.
Okay, because it's going to make a difference with the instructions. Because there's one way to do it without evidence, and there's another way to do it with evidence. By even if it's just one side, there's different.
I think we'll have evidence then. If it's a sentencing, we'll put something.
Okay. Well, why don't I? Are they gone?
I have one question, if I can approach, sir.
All right. Hang on just a second. This is a different topic, okay? The jury, I'm told, wants to have a dry erase board or and a marker back there with them. Are you okay with that?
Yeah.
Okay, yeah, give it to them. Just blank.
Yes.
Okay. Let's see, what was I saying? Oh, yeah. Well, so I'm assuming you're going to put on evidence, okay? Now, is it all right with you for me to take care of your, and this is all, only if they come back guilty on something, okay? And that we have a bifurcated stage, go over your client's testimonial rights if we get to a second stage.
Okay.
Is that all right?
Yeah.
Okay, so these are basically the same questions, Ms. Renick. You understand if we get to it at the punishment stage, you've got a right not to testify under the Constitution. And we're talking about the second stage if they come back guilty of something. You understand that? Okay, and do you understand that if you choose not to testify, your decision not to testify in the punishment stage won't be held against you? Okay, do you understand that the jury can be instructed not to draw any adverse inference about your decision not to testify in the second stage? Okay, and do you understand that if you do choose to testify, the prosecutor's going to have an opportunity to cross-examine, just like today, okay? Have you had an adequate opportunity to discuss whether or not you want to testify if we get to a punishment stage with your attorneys? You want an opportunity to do that? Okay, I'll just stop right there.
Okay.
All right?
How much time do we have?
Well, I don't know.
Oh,
I don't, you tell me. Okay, well, I don't think I can go any further because she wants to consult with counsel, so I'll pick that back up when we get a verdict. Okay? All right. All right, we're in recess.
All rise, please.